Thank you, Julie. That was great. I've noticed that not everybody has voted, and I don't know if that's because some of you are having technical problems operating the clicker. If you are having a problem operating your clicker, if you can just raise your hand and/or clicker. Okay, so everybody's working fine. Excellent. And just to remind everybody to return the clickers to the registration table when the day's over. These are not a parting gift, they're ours to keep. If you have any questions about Julie's presentation, two of our staff members, if you can just raise your hands, are on this side handing out index cards. You can just pick up one of those, write your question, and hand it back to them. You can also, if you choose, you can go to our Facebook page and send a question that way, or send it via Twitter, #CNTraining. If you're watching us on the internet, you can use the chat box on the right side to submit your question. Our next speaker is Elizabeth Newman. Elizabeth is the Director of Immigrant Initiatives and a clinical professor at the CUNY School of Law. She teaches at the CUNY School of Law. She teaches in the Immigration and Refugee Rights Clinic and manages an interdisciplinary gender violence program. Elizabeth is regarded as a national expert on the immigration provisions of the Violence Against Women Act, and we are very lucky to have her here today. Round of applause for Elizabeth.
The slides are going to change. Push. You're doing okay. Hi, everybody. Deep breath. You all get a resounding applause. That was a lot of information that Julie did a great job of walking you through, and it's going to serve as the basis for the piece that we're going to work on now, which is what happens when you get to the head of the line, okay, which is called adjustment of status. Okay, so this is, just so our study is complete here, this is the sections of the law where you'll find the instructions on the regulations on adjustment of status. All right, so we want to think of getting your green card in 3 phases. Julie just went through family petitioning, which is a large part of the first phase, right? So does somebody have a valid approved basis for their residency? All right, family-based is probably about 70% of legal immigration to the United States. What are some of the other ways that people can get a basis? Work is the next big one. Anything else people can think of? Oh, it's really hard. This is massive words. Somebody raise so I can hear one person. Humanitarian relief, like asylum, right? There's a bunch of bases, but the majority is family-based, and a majority of your callers will be family-based callers. So that's why we've spent a good deal of time on that. But that's just phase 1. Phase 2 is then, which we're going to work on now, is somebody eligible to get the interview that will get you the green card here in the United States, which is adjustment of status, or will the only option be consular processing in the home country? Okay, so you need your interview. At stage 1, what immigration's looking at is that really my mother? Is that really my sister, right? It's on paper. At the interview, the focus is then going to be on me. So maybe I did have a valid basis, but then I get to the interview, and maybe I've done something in my past that in spite of the fact that I have an approved petition, they're not going to let me have my green card, okay? And we're going to look at what that means. And then so after that is at the interview, when they'll go over what's called the grounds of inadmissibility. Things that, in spite of your approved petition, might make you ineligible to receive your green card. So the phase that we're looking at right now is, where can I get this appointment? Can I get this appointment? And then we'll talk about what happens at the appointment, okay? That's our plan. So what's adjustment of status, which I had said? So it's the process used by a non-citizen who's physically present in the United States to apply for lawful permanent residence, or your green card, without the necessity of traveling abroad. Consular processing, it's going to be basically the same interview, but it just means some people you'll see are not eligible to have the interview here. AOS is what we're saying, adjustment of status. And I would have to go to the US consulate in my home country to have that interview. So what are the benefits of adjustment of status? You can remain here. I don't have to interrupt my entire life. I have my job, I have my family. I can stay here and process here in the United States. After I apply for adjustment of status, while I'm waiting for my appointment, I'll get work authorization. There are more opportunities to litigate if there's a problem, if there's a denial. You also have the right to bring an attorney with you if you so wish, which you don't have that right at the consulate. And what we're going to take a look at, a concept of unlawful presence may not apply if I'm here in the United States. So let's take a look at that, because this is a key problem. It's actually considered one of the grounds of inadmissibility that we're really going to discuss later, but there's a reason we need to address this one ground now. So presence in the United States after the expiration of an authorized stay, or presence in the United States after I had come in without papers, okay, is called unlawful presence. I'm basically here without authorization, right? If I've been out of status for more than half a year, 180 days, but less than a year, if I leave the country, I can be barred for getting my green card for 3 years. If it's more than a year and I leave the country, I can be barred for 10 years from getting my legal permanent residency. The thing is, what I said is if I leave the country, right? You've got to travel outside the US in order for those unlawful presence bars to apply to you. There are some limited waivers if you can show hardship to a US citizen or a legal permanent resident, but if you don't trigger that ground, it's much better, right? So what it's basically saying is, if I overstayed my visa, et cetera, and have my interview here in the United States, am I going to get barred for unlawful presence? No, because I've never left the country. The bars only apply if after having accumulated unlawful presence, I leave the country. So the trick is, don't leave the country if you can avoid it, right? Okay, but here's the problem. Oops, it's not my problem, hang on. Okay, yep. All right, so let's look at the case study. This is the poll question? Okay, great. That's what we know as poll question. So this is our first one. Alicia overstays her tourist visa, which expired April Fool's last year. She now has her adjustment of status appointment scheduled based on a family-based application that her legal permanent resident husband filed for her 4 years ago. And the question is, for Alicia, will she have a problem with unlawful presence? All right, let's go over these. So A, yes, she may file for adjustment of status. B, no, she must apply for an immigrant visa abroad. C, no, she will be barred for 10 years because she has more than 1 year of unlawful presence. D, yes, she may adjust status, but only with an application for a discretionary waiver. And E, yes, she may adjust because she didn't leave the US and didn't trigger the bars. Okay, this is a 30-seconder. Okay, you guys did it right. All right, knew it was a sharp audience. Okay, so yeah, she didn't leave the country, didn't trigger the bars, no problem. Okay. So we want to go back, just remembering, 3-step process. So again, the fact that you have an approved basis doesn't necessarily guarantee your green card, right? two other things could happen. And sometimes you'll get a call from somebody that said, you know, my husband filed for me 7 years ago. Why have I not gotten my interview? Because you only did step one. You actually have to apply for step two. It's not the same thing, okay? So we really do have to treat each one independently. Okay, so the first thing you have to look at with my family petition that was approved, either on immediate relative or the preference categories, as Julie explained to you, my priority date and the visa bulletin, right? Do I have a visa immediately available to me, okay? So I get the approval in phase one, and when it's ready is when I'm at the front of the line. But you have to check, right? So now you know how to use the visa bulletin, you can check. All right, so here's another case study. Jessica came to the United States on a student visa. Last year, she married John, a legal permanent resident, who filed for her status on an I-130. The application was approved within 3 months. So far, so good. All right, can Jessica adjust? Yes, she may adjust. Yes, she may adjust. She may file for adjustment of status because she entered legally. B, she may file for adjustment of status because she is now married to a legal permanent resident. C, no, because she has to wait for John to naturalize. Or D, no, because she has to wait for the visa category to be current. 30 seconds. Okay, last pushes. All right, we have B, but that's what most people chose, is that correct? But that's actually a problem. All I wanted, actually the right answers were yes, I would accept two. Yes, she may file for adjustment of status, but then the question is why? That's not the best answer. The best answer would have been that yes, she may apply because she, am I the right thing here? This is weird, hang on a sec. We have a technical glitch here. Yes, she may apply for adjustment of status because she's now married to an LPR, but what did we have to look at? We have to look at the visa bulletin and all of that stuff, right? So basically D, no, she has to wait for her category to become current, all right? D, she'll eventually be able to do adjustment of status because she came in legally, but she's got to wait for that basis to become valid, okay? For some reason it's not following me. All right. Okay. All right. So now let's look at the eligibility. What are the rules for who's allowed to do the interview here and who's got to process back in the home country? These are the relevant sections of the Immigration and Nationalities Act. So A is the general rule, C is going to be exceptions to the general rule, and I are special waivers. That's what we're going to go over. So the general rule is if you were inspected and admitted or paroled, or you have an application under the Violence Against Women Act that Julie had mentioned, special provisions for battered women, then that's the first criteria. You must be eligible to adjust status. You must be admissible or not inadmissible, which we'll look at. You have to have an immigrant visa immediately available, right? A current priority date, or you're an immediate relative. And adjustment of status is discretionary. So that means that the officer you're sitting in front of at your interview, even if you meet all the criteria, if there's some negative history in your life, even if it technically doesn't get in the way, they have the discretion to deny you. Okay. So let's look at A, the general rule. So when you come in, you usually have a little card in your passport. That's the I-94 that says when you came in, how long you're allowed to stay, etc. If you're admitted with your passport, or you're even considered admitted with a false passport if you could show that you had used it. If you're paroled for humanitarian reasons, or sometimes border entry cards of different types are considered a legal admission. All right, so that's one of the keys to satisfy that general rule. Now, so even if you are admitted, inspected, and paroled, 245C is a list of infractions of immigration law that can make you not eligible. So even if I came in with a valid tourist visa, I was admitted, inspected, and paroled, and now I have my husband applied for me and we have a current application, if I violated one of these things, I might not be able to have my interview here in the United States. Some of the things you'll find in 245C, if I came in on a crewman visa, that's out. If I've had unauthorized work, that can be out. Failed to maintain legal status, if I've dropped out of status. If I have come on a transit visa, they don't allow people who came in on transit visas to do adjustment of status. If I violated the terms of my visa, right? If I have come in on a tourist visa but I worked. If I came in on a student visa and I dropped out of school, those can be problems. However, there's many exceptions for immediate relatives. Who are immediate relatives? Spouses, parents, and minor children of U.S. citizens, okay? Most of these have exceptions. So if I had unauthorized work, but I'm an immediate relative, I don't have to worry about that. If I fit 245A, I'm still good. But if I'm not an immediate relative, these things can make me ineligible for adjustment of status, even though I have an approved valid basis, right? Okay. So, as we can see, this is a problem. So many people who have approved family petitions can't use them because if you can't fit into that 245A scheme, admitted, inspected, admitted, and paroled, or you've done some violation under 245C, one of those, I violated my visa, that means I can't do adjustment of status. And I've got to do what? I have to travel home, right, and have the consular interview. But if I've overstayed my visa and I have unlawful presence, those 3 and 10-year bars will come and get me as soon as I leave the country, even if it's to go to my consular interview. So we have a lot of people who are really stuck, right? People might call you and say, I just married a U.S. citizen. I'm good, right? Not right. How did you come into the country? If you weren't admitted, inspected, and paroled, if you entered without inspection, even if you're married to a U.S. citizen, and even if he filed an I-130 that's approved and they believe that it's a valid marriage, you can't adjust status here. And if you leave the country to ask for the interview in your home country, you're going to be barred by the 3 and 10-year bars. Okay? So this is a problem, but we have a little saving grace. All right, some people can be saved by 245I. All right? And this is, you can ask on the phone to kind of see and then send somebody off to an expert to really navigate this, but you guys should know that this exists. So 245I is another section of the code, and some people in the community know it as like a waiver, like, oh, I applied for 245I. You'll hear that sometimes. So it basically means that if you don't fit into 245A, or you would have, but 245C, you violated something that messes it up for you, sometimes you can use this. So if I filed either a family petition or an employment-based petition, in these dates, I have like a get-out-of-jail-free card. So the first period of 245I was until January 14th, 1998, okay? And the second period was until April 30th, 2001, as long as I was present on the day that the law came into effect. So basically, these are numbers to remember. The important thing is the April 30th, 2001. If somebody has an old petition that was filed for them before that date, then they can still adjust status here in the United States. Or any ties, as you'll see, to an application that was filed for them before that date, okay? So they are considered grandfathered, and they have to pay a super fee of $1,000, all right? And then their sins, immigration-wise, are forgiven for the most part, and they can adjust status, okay? So let's see how that works. All right, so we have Marco Frontera. He paid somebody else to guide him across the Sonoran Desert in 1990. He managed to evade border patrols, and he has not left the U.S. since his initial entry. He worked for a small resort hotel for over a decade, and then filed an application for a labor certification. The resort did, yes, on his behalf in March of 1997. Dates? Listening for dates, right? Okay, it was approved, as was an immigrant visa that was filed for him in 1999. So he filed an adjustment of status application in the other worker category, which you don't have to worry about, when his priority date became current in March of 2001, but the application was denied due to a decline in the company's fortunes. And by 2000, they could no longer afford to pay him the offered wage. So that didn't go well for him. Now, his wife, Anna, is a legal permanent resident, and she filed a petition for him in June of 2009, which is now current. So you just read the visa bulletin, you look and say, excellent, his wife's petition is good. So this is the question now. Is Marco eligible to file for adjustment of status? Choices: yes, A; B, yes, but only once Anna becomes a U.S. citizen; C, yes, with proof of the labor certification from 1997; or D, yes, with proof of the approved immigrant visa petition from 1999. All right, this one is a 40-seconder. Okay, take your best shot. All right, most people got D, which is the correct answer. Good, you weeded through all that extraneous information here. So the important thing was that labor certification that was filed for him in 1997, way before the April 2001 date. And that is his get-out-of-jail-free card. Even if the petition didn't work, he's now trying to come through some other means, which is his wife. That petition, assuming he can have some proof that he had filed it, can now accompany an adjustment of status application with his legal permanent resident wife once that is current, which it was. So great, you guys did a good job. All right. Grandfathering. So as we see, the right to that 245I remains with the person, not the application, right? Marco got it from the labor cert, but now he wants to adjust based on his wife's petition. That's fine. It's Marco's right. It doesn't matter which application. The application can be used if it was properly filed. So that labor certification was filed on time. It was filed properly back in 1997. and it was approvable back then. So now, if the resort was just fictitious and somebody threw some paperwork in, it wouldn't work. But as long as it was valid at the time, even if the company went belly up or something else happened, as long as it was a valid application that was properly filed back when it was filed, he can now use that. Now, this is another good one, is that the benefits extend to derivative beneficiaries in the preference categories, okay? Right, because immediate relatives can't do derivatives, only on the preference categories. All right, so let's look at another one and see how good this grandfathering stuff is. All right, so now Marco's 18-year-old son, Samuel, came to the United States without inspection a year ago, last year. He had fallen in love in his home country, and he wanted to seek out his fortune here in the United States so that he could marry the woman of his dreams and start their new life together. Marco, the father, right? Marco's wife, Anna, has now naturalized, and she wants to know if she can help out by petitioning for Samuel. All right, so think about it. Here's our choices. So if she petitions for him, would Samuel be eligible to adjust status? A is no, because he entered without inspection. B, yes, because he's still a minor. C, yes, because he was a minor when the resort filed the labor certification for Marco, his dad. Or D, no, because he has collected more than 1 year of unlawful presence. All right, this is a 40-seconder. Think about it. Okay, take your best shot. All right, folks got A. Just find myself here. So let's go look back at the questions. A is no because he entered without inspection, but the concept we're trying to get is, can 245I extend to him? And actually it can, so the law is better than you thought it was. This is so rare. So let's look. B, because he's a minor, we don't really care about that now. 245I would say yes because he was a minor when the resort filed the application for his dad. That's what's key. And that, even though this law has not been in effect, since 2001, because of the grandfathering provisions, it can save a lot of people. So even though, and even if even if Samuel was no longer a minor, 20 years from now, he could still use 245I because his dad's petition was filed on time and he was a minor that could have been included on that old petition. He'll be able to maintain that 245I, that get out of jail free card, sticks with him as well as a derivative, okay? So the answer would be C. And the fact that he was out of status won't matter if he can adjust here and doesn't leave the country to trigger the bars, right? The bars only get triggered not just from collecting the presents, but for then leaving the country. Okay, so this was a packed one. All right, so 245I is great, we like it, but we want to be careful about what it's not. And many people will confuse it and say, I want to apply for 245I. That's not a path in and of itself, right? You'd need a family petition, or you'd need an employer who wants to sponsor you now, and then be able to tie it back to some old petition that was filed on your behalf or on a parent's behalf while you were a child, okay? So it's not a path by itself, but it's a way around the rules, the restrictions on who can adjust status here. Nor is it a protection for the 3 and 10-year bars. So if you travel, so the fact that I have say Samuel would have 245I, the fact that he had collected unlawful presence won't bother him if he can stay here. But if he says, I have this get out of jail free card, If somebody travels voluntarily now, they're not protected, okay? So we want to be careful what it's not. All right, another case study, which I think I might have just given away. Marco's son Samuel can no longer stand being away from his true love, and unbeknownst to you or his father, he sneaks back and forth across the border, undetected, to spend a couple of days with his honey. All right. Now, is he still eligible for adjustment of status? Questions, the answers could be A, no, because he entered again without inspection. B, yes, because he's covered under 245I. C, no, because he has collected more than 1 year of unlawful presence and then left the country. D, yes, because he was a minor under 21, the unlawful presence doesn't count. All right. Think about it. Oh, gosh. Okay. All right, we're done. Oh, sorry. Can we close the poll? We have to move. All right, so we came up with C, which is correct. It doesn't matter that the inspection problem isn't his biggest problem. 245I doesn't save him if he voluntarily blows it and leaves the country. The idea was it saved him because he didn't have to leave the country. So he did trigger the bars. And the fact that unlawful presence, that's not right. Okay, we have to now move faster. All right, Julie had mentioned some special provisions for under the Violence Against Women Act. Just to know, if that is the basis that somebody had already approved, they can adjust status under 245A. Quick case study. Actually, you know what? I think we're going to skip this in the interest of time. But just what I want to illustrate is that 245A, that first section that lays out the rules for who can always adjust status, specifically says inspected, admitted, and paroled, or VAWA. Okay? So that means if somebody now has the basis as a battered spouse, even if they weren't inspected, admitted, and paroled, they can still adjust status here in the United States. That big or makes a difference. In addition, 245C, which normally knocks out people who violated immigration laws, it also has a blanket exception for VAWA self-petitioners. So this is really helpful. Okay. Now, we're going to hit that stage 3. All right, so 1, do you have a basis? 2, can you fit into the rules of who's allowed to process here, or do you have to look for your interview back in the home country? This is what happens at the interview, those grounds of inadmissibility. So some of the big ones are public charge. If you have never worked and you're always getting, you don't have any means at all, and generally for that, people have to do an affidavit of support where somebody takes financial responsibility for you. Health-related grounds can get you in trouble if you have a communicable disease that's not under treatment, etc. Each of these could be its own seminar, but just to know some of the things. Certain immigration violations, like the 3 and 10-year bars, right, and others. Criminal grounds, which you're going to hear about in the next speaker, and certainly grounds of terrorism are a big deal that can really never be waived. All right. Now, these are the same things that will be scrutinized whether that interview happens here in the U.S. or back at the home country. There are exceptions for some of the grounds of inadmissibility, and there are also waivers. So, for example, you might have a criminal ground, but as you'll see, if it's a very tiny amount of marijuana, that ground's not going to apply to you. But then even if I do have a criminal conviction that does apply, sometimes you can get a waiver, and we'll hear about that in a bit. But that's the stuff that happens at the interview. The focus is now on me as well as the validity of the basis. Okay, just so that you know, we're focusing on the family petitioning process. But if the basis of your green card is something else, there's different rules. It doesn't quite follow the same way. So these are some of the examples of different rules. And there's also fewer grounds of inadmissibility that might apply. So just know that this was for the family petitioning. Okay, procedures. The form that you use is the I-485. These are the forms that are listed. Everyone needs a medical exam, the affidavit of support, and proof of that basis, okay? The fees are listed here. They're high, okay? You can see that. And then worse, if you're filing under 245I, in addition to these fees, you also have to pay an extra $1,000 per person who's using the 245I exception, okay? So we're talking about, if we have a family of 4, that's, you know, we're talking about 10 grand of just fees, okay? How am I time? 5 minutes? Or you're not holding that up yet? All right, good. Case study, so let's revisit Marco. He entered without inspection in 1990. He's seeking to apply for adjustment of status based on his petition from his wife. Remember, he's going to bring proof of that resort petition. So how much does he have to pay? Okay, what fees? None. He's not eligible in the first place. B, $1,070. C, $1,000. Or D, $2,070, which is B and C combined. Or E, $685. This is a 30-seconder. I didn't give you a lot of time with the numbers, so. And close. Okay, you guys got it. You were paying attention. It's both the regular adjustment fees of $1,070 plus the $1,000 because he needs to pay for his immigration sins under 245I. So that'll be the fee just for him, okay? All right. And then, of course, if it's Samuel, now we're up to $4,000 for the 2 of them. All right. Special procedures under the Violence Against Women Act, they'll never have to pay the 245I fees because they always fit into 245A, right? Remember that exception, inspected, admitted, paroled, or VAWA. So they won't need that extra exception because they're in the primary part. Medical exams are still required. Even if there's no sponsor who's going to sign the financial sponsorship, there's a particular form that waives it. Anyway, so it's pretty much the same thing, but just the fees will always be just the regular fees. What else is important for you guys? Yeah, so there's some of the other bases that I mentioned. If you're doing it as a refugee, or if you're doing adjustment of status not on the family petitioning one, oftentimes there's no interview. It's just done on paper when someone's ready to send in the paperwork, unless there's criminal grounds. And most of the grounds of inadmissibility don't apply. Like, so most immigration violations, that you've worked without authorization, that you came in with a fraudulent visa, if you're coming in as a refugee, that won't knock you out of the game. But anything, usually the terrorism grounds, and often some of the more serious criminal grounds can still apply. Okay, I will end on this cautionary note. When somebody says, I just want to ask a simple question, I'm in the process of adjusting status, I can travel, right? Beware. And as you'll know from the 3- and 10-year bars, beware. Somebody could be making a major mistake. Even if they're allowed to travel, it's really loaded. So tell people that it's not a simple question, and they really should talk to one of the people at Citizenship Now or to an attorney. Okay. All right. Deep breath. That was a lot. Thank you.